Nice. Good day, everyone. You are welcome to Property Law Practice. We'll be looking at Contract of Sale of Land and Registered Conveyancing Part 1 in this lecture. There are certain things we expect you to be able to do at the end of this lesson. One, we expect you to be able to mention the laws that affect sale of land in Nigeria. 2, mention legal restrictions to sale of land. 3, list the various steps in the sale of land transaction. 4, explain the need for a pre-contract inquiry. 5, mention various types of contract of sale of land in Nigeria. 6, we expect you to be able to discuss the principles governing each type of contract of sale of land. 7, apply the principles governing each type of contract of sale of land to a case you will be given or to given cases when you begin to practice. 8, state the procedure for exchange of contract and the effect of exchange of contract on the parties in a sale of land transaction. 9, you'll be able to state the capacity of a solicitor to act for both parties in a sale of land transaction. Then 10, you'll be able to draft a formal contract of sale of land. Now we go on to what is conveyancing. We can simply say that this is the process by which interest or rights in land, that is realty, different from personality, are created or transferred from one person to another. There are usually two parties in a sale of land or conveyancing transaction. The person selling, who is known, or the person transferring his interest, who is known as the vendor or seller. Then at the completion stage, we refer to him in the final document as an assigner, or the person to whom the interest is being transferred, who you can call the purchaser or refer to as the purchaser or the buyer. Then at the completion stage, in the final document or transfer, such a party is referred to as the assignee. Now, for a sale of land transaction in Nigeria, is broken, we could broadly break it into two stages for purposes of the documents to be drafted. The contract stage. At the end of that stage, when negotiations have been concluded, terms have been agreed upon, the document drafted is known as Contract of Sale of Land Agreement, and the parties under that contract are referred to as the vendor, purchaser, or seller, buyer. Then at the end of the entire transaction, when title has been deduced, investigations have been carried out, they are ready to go on to completion. The document that will be used to transfer the totality of the interest of the vendor in that property, be it legal or equitable, to the purchaser or seller is known as a deed of assignment. And in a deed of assignment, the parties are usually referred to as the assigner for the vendor or the assignee for the purchaser. Now, that takes us to applicable laws. You refer to week 3 when we did the overview of the course. All the laws that were stated there, you refer back to them in respect of applicable laws. And you should know in Nigeria, for purposes of sale of land or conveyancing practice, the country is divided into three. We have the CA states, that is the Conveyancing Acts of 1881 and 1882 states, comprising of the northern and eastern states of Nigeria, and part of the south states, talking about Akwa Ibom, Cross River, Rivers State, and Bayelsa State, together with the eastern states and the northern states, are broadly or generally regarded as the CA or Conveyancing Acts states. Then we have the Property and Conveyancing Law states, referring to Old Western Region, which presently consists of Ogun, Oyo, Osun, Ekiti, Edo, and Delta states. They are governed by principally by the PCL. Then Lagos, prior to this time, was under two different legal regimes when it comes to property transactions. That is the Conveyancing Acts and the Registration of Titles Law. But presently, Lagos, the principal statute or legislation dealing with this sale of land in Lagos State presently is the Lagos State Land Registration Law of 2015. Now let us move on to, on that note, let us move on to means of acquiring land in Nigeria. One, customary law. Of course, the majority of the populace in Nigeria are governed by one customary law or the other. Therefore, where a land is family or communally owned, any member of that family or community can acquire interest in modern times through various means such as allotment, partitioning, or gift inter vivos. But gift inter vivos under customary law, please you should note, is an oral pronouncement by a grantor in the presence of witnesses, and the person whom is making the gift of land to, known as a grantee, is expected to take possession during the lifetime of the grantor. Now, a second means of acquiring land is via inheritance. Property interest that an owner rather may have acquired through any of the means of acquiring land in Nigeria can devolve on a beneficiary, either through customary rights of inheritance or through probate. And when we talk about probate, it includes letters of administration. Then 3, government allocation. State interest in state land are usually acquired by allocations from the requisite government, either of the state or in the case of FCT, from the minister of the FCT. See the case of Iseru and Catholic Bishop of Warri Diocese. Then by purchase, the fourth means of acquiring land is by purchase. This refers to outright sale by an holder of land who had acquired interest in that land through any of the means we've discussed so far, transferring the totality of his interest to the purchaser. 5. Gift inter vivos. By gift inter vivos, the owner of land transfers his interest as a gift. He gifts it to another who is the object of his love or bounty or for whatever reason. But as a solicitor, you should understand that it is not enough, once it is not a gift inter vivos under customary law, it is not enough for the gift to be made in writing. You should advise your client, if your client is the grantor, you should advise him on the importance of making such a gift by deed. We move on to restrictions on disposition of land. We have statutory restrictions, customary restrictions, judicial restrictions, and contractual restrictions. For example, for statutory restrictions, we have certain restrictions under the Land Use Act of 1978. And we'll look at this quickly. Under the Land Use Act, restrictions on the disposition of land by an holder of land. One, the first under the Land Use Act is the abolition of absolute ownership by virtue of Section 1, 5, 6, 34 sub 2 and 36 sub 2 of the Land Use Act. Then we have the issue of consent too, by virtue of Section 21 and 22, that makes the consent of the governor for a statutory right of occupancy or the local government for customary right of occupancy a condition precedent for a valid sale. See the cases of Savannah Bank and Agilo, Abioye and Yakubu. And then the fact that a vendor applies to the governor for consent to transfer his interest, does it translate automatically to consent being given? The answer is no, because on the authority of the Queen and Minister of Land and Survey as parte Bank of the North Limited, consent is discretionary. Then the third restriction under the Land Use Act is with respect to age limitation. By virtue of Section 7, a statutory right of occupancy or consent to the assignment or subletting of a right of occupancy cannot be made to a person who is under the age of 21 years, who is less than 21 years old. And the fourth limitation under the Land Use Act is as it affects the quantum of land that an individual can hold in urban areas where land is developed. When the piece of land is developed by virtues of Section 6 sub 2 and Section 34 sub 6 to 8 of the Land Use Act, there are restrictions as to the quantum of interest of land rather that you can acquire. Then, by virtue of Section 36 sub 5 on the provision against fragmentation of land in rural areas, this also operates as another limitation. Fragmentation of land in rural areas. And finally, under the Land Use Act, By virtue of Section 46 sub 1A, a right of occupancy cannot be granted or transferred to a person who is not a citizen of Nigeria, except with the approval of the National Council of State. Then other statutory restrictions, apart from the Land Use Act, that we will come across is in regards to properties owned by government ministries and parastatals. This will occur where in a particular ministry, the enabling legislation establishing it expressly provides for the consent of the minister in charge of such a ministry, or where it is an agency or government, the minister that is supervising that agency. The consent of such a minister must be obtained before you can transfer or sell any property belonging to such a ministry. This is by virtue of the enabling law establishing that ministry. So if there is a ministry that the enabling law establishing it does not provide for such consent, they can go ahead or makes a different provision as to disposal of properties owned by that agency, then it is the enabling law that is followed. Also, by the various town planning laws and regulations we have in Nigeria, you see that land use, especially in urban areas, have been demarcated into residential, commercial, industrial, and so on, different purposes. The fact that you are an holder of land, if that land or that area is demarcated that it is for residential, irrespective of the fact that you are the owner of the piece of land, you cannot sell it where it has, for example, stated to be residential. You cannot sell it to Oando to build a fuel dump, or sell it to PZ Nigeria Limited to build a factory. So all these legislations, the various town planning laws and regulations, they also limit the use to which an holder of land can put his property. And of course, we have provision for public utilities. This also serves as another restriction. For example, a place that has been demarcated, maybe as a fadama, even if you have property there and you build on it, it can be pulled down. You can't go ahead, or it has been demarcated as a green area. So the various laws under this head regulate the manner in which an holder of land will deal with his property or put it to use. Then, of course, you know, certain lands have been earmarked for overriding public interest purposes and can even be acquired, even if it belongs to you. Government can acquire it for overriding public purposes for the sake of provision for public utilities and infrastructural purposes. Please note that. Then under customary restrictions, we have just discussed statutory restrictions. Now, another restriction on disposition of land in Nigeria falls under customary law. And this will happen where the ownership or title to land is vested in a community or family. Management and control of such lands usually remain or vest in the head of the community or family and the principal members of such a family. Take the case of Amodu. Tijani against Secretary of State, Southern Nigeria. Therefore, for there to be a valid sale of such land or property belonging to a community or family, the consent of the head of that community or family and its principal members must be sought and had. Otherwise, such a sale will be void. In the same vein, where the family head goes ahead to sell or transfer any family land as his personal property, such a sale by the family head is also void. Or rather, then where the family head goes ahead to sell family land without the agreement of members of the family, such a sale is voidable and may be successfully challenged by the principal members or other members of the family. And then please, on this note, at this junction, you should know that under the Lagos State Land Registration Law, by virtue of Section 92, a disposition of family land executed by family representatives that are less than those appearing in the register is void. Now, judicial restriction. This is riding on the doctrine of lis pendis. And of course, you know why an holder of land, even though the land is his own, so long as it's a subject of litigation, he will be prevented from disposing of it until the outcome of that suit. This is principally to preserve the rest. See the case of Ogudia and Araba. Then contractual restriction. Contractual restrictions. This can arise from a contract or agreement between a vendor and a head lessor. For example, where the vendor, who is the holder of, who is purporting to sell now, who is proposing to sell, is a lessee or is proposing to transfer his interest by assignment, he's a lessee, or he's a mortgagor in another transaction, and he had covenanted not to assign his interest. For example, where that restriction, that covenant is absolute, he cannot validly assign or transfer his interest even when he's willing to do so. But where he is required to obtain consent from the head lessor or the mortgagee before he can sell or assign the remainder of his interest in respect of that property, he also cannot validly assign or sell without the consent of the head lessor or the mortgagee. On this note, we move on to stages in conveyancing. Stages in conveyancing. For purposes of our class, the conveyancing process is divided or subdivided into 5 stages. That is the pre-contract, the contract, post-contract, completion, and post-completion or the perfection stage. Now we're going to be looking at 2 of these stages in the course of this lecture, and they are the pre-contract stage and the contract stage. Now, when we talk about pre-contract, This deals with the process whereby maybe a purchaser is interested in the sale of land, is interested in acquiring a piece of property which may be developed or bare land. And after he makes inquiries, and after locating a piece of property, he goes ahead to negotiate price. That is why we say that this stage, the pre-contract stage, deals mainly with preliminary inquiries, or what you refer to as pre-contract inquiries, and the negotiation of price. Now, why do you think a purchaser should make pre-contract inquiry? In fact, what are pre-contract inquiries? What are pre-contract inquiries, if I may ask? This deals with preliminary gathering of information relating to the property under consideration by a purchaser or his solicitor. Pre-contract inquiries are preliminary gathering of information relating to the property under consideration by the solicitor to the purchaser or by the purchaser himself. And why he will do this is that the result or the information he gathers, the answers to his inquiries will enable him decide on whether he wants to go on to negotiate the price with a view to executing a binding contract or not. And I think at this point, we just look at the need. It's one of them that we have mentioned. It will help him reach a decision on whether he wants to go on to negotiate further with the vendor with a view to executing a valid contract, because it is his duty, the purchaser's duty, to verify information or to gather information at this stage. And any information he seeks and the vendor answers, he must verify, because he must be cautious, by the rule of caveat emptor, buyer beware. So preliminary inquiries enable him to have a general picture and also show forth latent defects, which of course the vendor is required to disclose at this stage in respect of the property. See the case of Yandel and Sutton, and Ejigini and Ezenwa. Also, pre-contract inquiries is important because depending on the result of his inquiries, he will be able to evaluate his financial capacity. Maybe he had in mind of purchasing a property of maybe not more than 3 million, but he had just seen this choice piece of land and he loves it. After making all the inquiries as to, and ask different questions, the boundaries, the easement in respect of the property, the title documents, and so on. And he discovered that he loves the location of the property. All his inquiries so far have been quite satisfactory, but the property is going for, the asking price is 50 million. So pre-contract inquiries therefore will help him to evaluate his financial capacity. And if he still wants to go ahead, then he will begin to make financing arrangements. Let us move on. At this point, we said the rule is caveat emptor, buyer beware. Buyer beware, because at the pre-contract stage, it is not the duty of the vendor to disclose patent defects. That is physical defects that are visible to the eyes. It is not the duty of the vendor at this stage to disclose them. It is the duty of the purchaser, if he so desires, to inquire into them. But it is the duty of the vendor at this stage to disclose latent defects. Please note the difference. Latent defects, defects that are hidden, that are not visible to the ordinary eye. For example, as it relates to the title documents, the title of the property, it is the duty of the seller or the vendor to disclose latent defects. And then you should note, even though we say that it is not, the vendor is generally under no obligation to volunteer information as to physical or patent defects in the property. On the other hand, he must not also fraudulently conceal known defects or reply dishonestly to questions raised in respect of them. So please, you should note this. Where he fraudulently or dishonestly answer questions as to patent defects, where the purchaser makes inquiries with regard to them, he will be held liable for misrepresentation. Please note that. Now, maybe we should look at examples of pre-contract inquiry. What are some of those things or areas that you need to gather information in respect of if you are the solicitors to the purchaser and you are briefed at this stage? For example, you can ask the vendor's name, the vendor, his name and address, and this may even affect issues that have to deal with anti-money laundering provisions. Then the property, the description and address, is it vacant land, is it developed, the boundaries of the property, the nature of the interest, nature of documents of title, the vendor's asking price, have there been legal disputes in respect of that property? If the title documents are not in the possession of the vendor, then is in his possession, or if they are not in his possession, who is in custody of them and why is he in possession of them? You need to clarify those areas. You need to ask, at least have a preliminary understanding of those areas. Are there any adverse rights or restrictions on the land? You need to look into planning schemes affecting the property, facilities in the property where it is developed, details of leases, subleases, mortgages, and all other encumbrances affecting the property, and so on. These are some of the issues you should look at during pre-contract inquiries. Now, this takes us to contract stage. In practice in Nigeria, at the conclusion of preliminary inquiries and negotiation of price by parties, they also have the choice of entering into an oral, open, or formal contract of sale of land. In fact, in Nigeria, the oral and open contracts are more common. The formal contract, though, is the preliminary step, or should be seen as the preliminary step in the transfer of title in land, is usually overlooked in Nigeria. And of course, this is as a result of our we say culture and our outlook, the outlook of the majority of the people in the country. But where parties agree to enter into a formal contract of sale of land, then the things you expect to see The issues that should be tackled under this head will be agreement on terms, the preparation of a formal contract of sale of land agreement and the execution of it. Then they will go on to exchange of contract after the execution of the document. And you should note, for a formal contract of sale of land, it must be in writing by virtue of Section 4 of the Statutes of Fraud. It must be in writing. Now we go on to look at types of contracts of sale of land, which we'll be looking at when we come back from our break. Thank you.